Back in the breakout session. Ms. Underwood, do you know how Mr. Raymond would like to proceed today?
Yes, Your Honor, thank you. Mr. Raymond would like the court to enter a not guilty on his behalf in this matter. The underlying case is Public Defender Murphy's, Your Honor, and we would ask that this be set over for next week, next Wednesday, with Public Defender Murphy.
Okay, I'll enter not guilty plea for Mr. Raymond in both files. I'll set it for a pretrial on the underlying cases and the contempts on November 6th at 8:15. All right, Mr. Raymond, you can let them know that you're done with court for today.
All right, thank you, Your Honor.
Okay, Ms. Underwood, I have Mr. Bowker here. Do you need to speak to him?
Yes, thank you, Your Honor.
Antoine Simmons for Judge Osaka. All right, thank you.
Mr. Bowker, if you can hear me, I need you to unmute your device and start your, start your video. There you go. You just need to unmute.
All right. Sorry.
So I'm going to put you in a breakout session with Ms. Underwood.
All right. Thank you, Your Honor.
Okay, Mr. Dagger Rogosian, Ms. Orwig is here. Do you need a breakout session with her?
Your Honor, I don't, unless you need to speak with me. I know what the plan is moving forward here.
Okay, I'll bring her into the meeting right now. All right, Ms. Wood, do you want to speak to Mr. Dagger Rogosian before we start?
If I could, Your Honor.
And Judge, I just wanted to give you a heads up. This one is potentially a HIDA plea, and I know sometimes you clear your courtroom for those, so just logistically, it may make sense to do it a bit later.
Okay, I appreciate that. Thank you. Okay, Ms. Chartier, are you ready to proceed with Mr. Warner?
Yes, Your Honor.
Okay, this is file 24-21841-FC, People of the State of Michigan versus Dale Warner. We are here today for a pretrial conference in this case, and we are proceeding today in person and by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who's appearing by video. Thank you.
All right, and I am aware there's been some communication regarding scheduling trial dates, and it looks like the parties have agreed on a trial commencing September 2nd of 2025 and running through October 14th of 2025. Is that accurate?
That's correct, Your Honor.
That is, Your Honor.
Okay. I would suggest then doing a final pretrial conference on August 27th, if that works.
Yes.
Yes, Your Honor.
Okay. All right, so the court will put together a scheduling order and send that out. Is there anything else that we need to address in the case?
No, thank you, Your Honor.
No, just if we decide to get a motion date, we'll contact the court and potentially ask for a pretrial in January.
Yes, Your Honor.
Okay, yeah, obviously, if there are issues that come up between now and then, you're welcome to contact the court and schedule a date.
Yes.
Okay.
Thank you, Your Honor.
Thank you.
All right, thank you very much. Mr. Warner, you can let the officer with you know that you're done with court for today. Mr. Goldstein, you need to speak to Mr. Simmons.
No, Your Honor, I believe we're ready to proceed.
Right. So this is file 24-22017-FH People versus Antoine Simmons. Also 23-21368-FH. That one's set for probation violation. The 24 case is set for arraignment. First, let me have the attorneys place their appearances on the record, beginning with Mr. Hartzon.
Good morning, Mayor. Doug Harsung appearing for the people today.
David I. Goldstein appearing on behalf of Mr. Simmons in both cases, Your Honor.
All right, and with respect to the 24 case, Mr. Goldstein, does Mr. Simmons wish to have the information read?
No, Your Honor, we'll waive reading of the information. My client stands viewed as that the not guilty plea be entered.
All right, I will enter a not guilty plea for Mr. Simmons then. And
Your Honor, we have a resolution which
right.
Mr. Hartung is going to place on the record.
Okay, go ahead then, Mr. Hartung.
Thank you. Your Honor, Mr. Goldstein, Mr. Simmons, defendant will plead guilty to count 1. The balance of the charges will be dismissed at the time of sentencing. We would like to set the sentencing down the road a bit, 4 or 5 months, and we are going to discuss a bond release with certain conditions after the plea is entered today.
Okay, is that, sorry, Ms. Goldstein, is that complete and accurate statement?
It is, Your Honor. This resolution, I think, also includes the violation of probation.
Well, I don't have any authority to do that. That's
no. What I meant by that, Doug, is the sentencing, and that will be adjourned out to the same date as the sentencing. And that's what I meant by.
If that's acceptable with the court, that's fine with me.
So he's going to plead also to the probation violation, and then we'll set sentencing on everything for 4 or 5 months, I think we said.
That's correct.
Is that right?
That's correct.
Yes, Your Honor.
All right. So, Mr. Simmons, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Sir.
And you are Antoine Simmons?
Yes, sir.
Mr. Simmons, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, delivery or manufacture of cocaine of less than 50 grams?
Yes, sir.
Are you satisfied with Mr. Goldstein and the advice that he's given you?
Yes, sir.
Do you understand that the maximum possible penalty for that offense, and I'm sorry, Mr. Hartron, Mr. Goldstein, there's a second or subsequent controlled substance offense and also a habitual offender offense. Are those, what's happening with those?
Those will be dismissed as sentencing, Your Honor.
Correct.
Okay.
I'm sorry.
All right.
I'm sorry, Mr. Simmons, I think he's got his hand up. Go ahead, Antoine.
Oh, no, I didn't know if you wanted me to put my hand down. I just put it down.
Oh, sorry. Okay.
Okay. All right, Mr. Simmons, then, do you understand that the maximum possible penalty for this offense is up to 20 years in prison and or a $25,000 fine?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than, as we've discussed, the delay in sentencing today. Is that correct, Mr. Hartung?
Your Honor, one more thing we didn't put on the record is that we had agreed that the sentencing in this case, the initial sentencing in this case, would not exceed 1 year in jail.
Well, probationary sentence with up to the 1 year in jail, correct?
I'm sorry, Mr. Goldstein, your audio was a little bad there. What was that?
I think what Mr. Hartung and I agreed was that sentencing would be a probationary with no more than 1 year in jail.
Okay, is that correct, Mr. Hartung?
I believe I understood that correctly. And the initial sentence would be up to 1 year, and then he'd be put on probation after as part of the plea process.
Right. That is, I don't know what the problem with the audio is, but that is what I said, Mr. Hartung. Yeah.
Okay.
Okay. So other than that, no one has discussed a possible sentence with the court. Is that correct, Mr. Hartung?
It is, Your Honor.
Mr. Goldstein?
That's correct, Your Honor.
And is that also your understanding, Mr. Simmons?
Yes, sir.
If the guilty plea is accepted, there'll be no trial. That means you will be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Simmons, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
I'm sorry, the audio there was bad. Was that a yes?
Yes, sir.
Thank you. Do you have any questions about any of the rights that I've explained to you?
No, sir.
You understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about July 16, 2024 in Lenawee County, Michigan, that you did commit the offense of delivery or manufacture of cocaine less than 50 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
You understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is your defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Simmons to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Simmons, other than as it's been stated on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Goldstein, do you want to cover the factual basis?
I will, Your Honor. Mr. Simmons, on or about July 16th of 2024, were you in the county of Lenawee, state of Michigan?
Yes, sir.
And did you have in your possession at that time less than 50 grams of cocaine?
Yes, sir.
What were you intending to do with that cocaine? Were you going to give it to someone? Were you going to share it with someone?
I was going to share it.
Okay. And you had no license or permission to have that cocaine, is that correct?
Correct.
And you believed that whatever you had in your possession was in fact cocaine?
Yes, sir.
Yeah, I think that covers it, Your Honor.
Mr. Hartung?
I'm satisfied, Your Honor. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Hartung?
Yes, Your Honor.
Yes, Your Honor.
All right. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Simmons has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here today. I will refer this matter to the probation department for pre-sentence investigation, and we'll set sentencing for, we'd be looking at about March or April.
Yes, Your Honor. And if we could have it after the 20th of March, Your Honor.
20. Okay, so let's go with April 3rd at 8:15.
April 3rd. That works perfectly. Thank you.
Your Honor, you said April 3rd at 8:15?
Correct.
Okay.
No, Your Honor. Well, Mr. Hartung and I are going to address bond in just a moment, but because we're setting sentencing out that length of time, I would request that we set the pre-sentence interview for some time, maybe in February or March, rather than now, because that's a pretty long. And by the time Ms. Teskey or whoever prepares the pre, if they do it now, it's going to be out of date by the time we get ready to sentence.
Okay, is there any issue with that, Ms. Teskey?
Your Honor, we have deadlines, so what we could do is the initial pre-sentence report right now and then do an updated case report closer to.
That's fine, Your Honor.
Okay. Why don't we do it that way then?
Okay, thank you.
All right, then what do you want to discuss about bond?
Go ahead, Mr. Hartung.
Your Honor, I don't have an objection in letting the court set a PR bond in this matter. Subject to review by this court, along with any necessary input from Darren Coast. We believe some of the conditions to bond should be drug testing, random or otherwise. Initially, probably a tether that could probably be reviewed after 2 months. No contact with Michael Santiago Sr. or Michael Santiago Jr. Mr. Simmons is not to be within 500 feet of 2752 Cloverdale Avenue in Adrian, and any other conditions that the court or Mr. Coast recommends.
I don't have a problem with that, Your Honor. Do you understand, Mr. Simmons?
Yes, sir.
Any comment about the conditions?
I understand.
Okay.
So based on that, then I will grant a PR bond with the requirements that Mr. Simmons make reports to Mr. Coast as often as directed by Mr. Coast. Do not use alcohol, marijuana, or any illegal controlled substance. You participate in substance abuse testing or monitoring on a regular and random basis. You participate in a substance abuse treatment program if you're directed to do so. You have no contact with Michael Santiago Jr. or Michael Santiago Sr. That you not be at the address 2752 Cloverdale Avenue in Adrian. I am going to require GPS tether along with a curfew of 7 p.m. to 7 a.m. And you may not use or possess a firearm or any other kind of weapon.
Yes, sir.
So when you're released, Mr. Simmons, you need to come directly over to the courthouse and speak to Mr. Coast. You're going to need to give him your address where you're going to be living so that we can monitor the curfew.
Yes, sir.
All right. Is there anything else we need to address with Mr. Simmons' case today?
Not to address, Your Honor, just a question to Ms. Teskey. Are you going to be doing the pre or
Who is his current, I see that he has a probation violation. Who is his current agent?
who's your agent, Mr. Simmons?
Mr. Moore.
Mr. Moore, okay. Mr. Goldstein, I don't know who his agent is, but I need him to report to me. If he's gonna get out of jail today, I need him to report to me today so we can figure out who's gonna monitor this case.
Okay, if you get out before 5 o'clock or before 4 o'clock, Mr. Simmons, contact Ms. Teskey today. If you get out tomorrow, contact her tomorrow.
Okay.
8 a.m. tomorrow. If you don't get out before 4 o'clock, Mr. Simmons, I need you here to see me. My name is Sarah Teskey, and I need you here to see me at 8 a.m. tomorrow.
Okay.
Okay? But try to make it today. If you get out today, I want to see you today.
Yes, ma'am.
Thank you.
All right, thank you, Your Honor. Thank you, Mr. Hartung.
Thank you.
I apologize. I had not done the plea on the violation of probation,
You're right.
so I still need to go through that. So, Mr. Simmons, you understand that with respect to the violation of probation, you also have a right to contest that and have a trial on that.
Yes, sir.
You understand that throughout that trial, you'd be presumed innocent until guilt is proven by a preponderance of evidence.
Yes, sir.
You'd also have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses you have for your defense to appear at that trial. You understand all of that.
Yes, sir.
Again, you have the right to test. You don't have to say anything at that trial, and no one can say anything about you not testifying. On the other hand, you'd also have the right to testify if you wanted to testify. Do you understand that?
Yes, sir.
Do you understand the maximum possible penalty for the offense in the violation of probation file? You'd originally pled guilty to larceny by conversion, $1,000 more, but less than $20,000 with a habitual offender third offense notice. And so the maximum possible penalty would be up to 10 years in prison.
Yes.
How do you want to plead to the charge that you violated your probation?
I'm pleading not guilty, right?
Oh, it's you're admitting the violation. That's part of the deal.
Okay, yeah.
Okay, so if you want to plead guilty to it, I need you to say guilty.
Right, guilty.
Okay. Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've just explained to you?
Yes. Yes, sir.
Has anything been promised in order to get you to plead guilty?
No, sir.
Have you been threatened in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
All right, so the allegation is in the violation of probation is possession of firearm and possession of narcotic. I will accept the admission of the possession of narcotic as violation. We've already had Mr. Simmons admit the factual basis on that, so I don't think we need to do anything further with that regard. In that regard, so I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Simmons has had full knowledge of his rights. He's had competent counsel. This one will refer to the probation department for an update of the pre-sentence investigation and set sentencing for that same date. So Mr. Simmons, someone from probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yes, sir.
Bond on this case will be modified to be consistent with the 24 case.
Yes, sir.
Is there anything else we need to address today?
No, Your Honor.
No, Your Honor.
Okay, thank you, Mr. Simmons. You can let the officer with you know that you're done with court for today.
Yeah.
Okay, Ms. Underwood, are you ready to proceed with Mr. Bowker?
Yes, she is, Judge. Once she turns back on, she is.
Yes, we are, Your Honor. Thank you.
Okay, this is file 24-21719-FH, People versus James Thomas Bowker. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Bowker this morning, Your Honor.
All right, and where do we stand with Mr. Bowker's case today?
Mr. Bowker is making payments, Your Honor. He's making progress. We're trying to get Mr. Bowker down to a $9,500 level for a attempt plea in this matter, Your Honor. And I think I've discussed this with Ms. Brenner, and I think that January 15th day for another pretrial looks pretty good if the court would be so kind, and I would be happy to do the stipend order.
Okay, Ms. Brenner, is that agreeable?
That's correct, Judge. He's paying well. We're in the right direction here.
Okay, so we'll set this, adjourn this to January 15th then at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Bowker. You can go ahead and log out. Ms. Underwood, Daven Ryan is logged in. Do you need to speak to Mr. Ryan?
Yes, I do, Your Honor.
Okay, Mr. Solid, do you have Mr. Bishop in your office with you?
I do, Your Honor.
Okay, give me 1 second. I'll be right with you. Okay, this is file 23-21238-FC, People of the State of Michigan versus Nicholas Joseph Bishop. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Good morning, Your Honor. Stan Sal on behalf of Nicholas Bishop.
Okay, so where do we stand with Mr. Bishop's case today?
At this point in time, Your Honor, I think and more discussions need to be made between myself and Mr. McCready. I think probably another pretrial at this point, or in the alternative to set for trial, but I think a pretrial might help first.
Mr. McCready, anything to add from the people's side?
No, I agree with that.
All right, so the case is 641 days since bind over. I appreciate the desire to have further conversations, but I think we need a hard deadline. So I'm going to set a trial date. How much time do you think y'all will need for trial?
Probably 2 days.
Yeah, I'd say 3 days.
Okay. Ms. Clark, can we have a 3-day jury trial date, please?
Yes. Tuesday, February 4th at 9 a.m., February 5th, Wednesday at 10:30, and February 6th at 9 a.m.
I believe that works for the people.
Yeah, it would work for me.
Okay, so we'll set a final pretrial then on January 29th. At 8:15. Obviously, if you resolve the matter in the meantime and you want to schedule it for an earlier Wednesday, you're welcome to do that.
Okay, January 29th at 8:15.
Correct.
Okay.
Is there anything else we need to address with the case today?
No, Your Honor.
Okay, thank you then. I will send out a scheduling order with trial dates and final pretrial in it.
Okay, so just to get it right, 9 a.m. on Tuesday, 10 a.m. on Wednesday, and 9 a.m. on Thursday.
Correct.
All right, thank you.
Okay, thank you. All right, Ms. Underwood, are you ready? Yeah.
Mr. Ryan never came in my breakout.
Oh, I'm sorry. Let me try that once more. Maybe Torres, I haven't back. No, that's not.
Your Honor, I'm supposed to be doing bond reviews and district court, and I see Mr. Clayton is in your waiting room also. I think that could be really quick if you want to call.
Yep, I was just about to ask to call for him at the jail. So Mr. Jacobs and Mr. Torres.
Hello, it's County Judge Simmons. Could we have Andrew Jacobs and Randy Torres in for Judge Simmons, please? Thank you. Bye.
All right, Ms. Underwood, are you ready to proceed with Mr. Ryan?
Yes, thank you, Your Honor.
This is file 24-21881-FH, People versus Daven Scott Ryan. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record? Not sure who we have from the prosecutor's office on this one. Appears I've lost. Oh, there's Mr.
Sorry, Judge, I thought you were calling Mr. McCready's case. I apologize. Phoebe McClure on behalf of the people.
Rhonda, I'll do it on behalf of Mr. Ryan this morning, Your Honor.
Okay, and where do we stand with Mr. Ryan's case today?
Your Honor, based on information I received yesterday during our Cobb's conference, and some issues that have come up, I believe it's appropriate to take one adjournment in this matter and find out where things stand on that other issue that Mr. Ryan may have prior to a final resolution on this, Your Honor. So I would ask for an adjournment.
Okay, Ms. McClure, is there anything you need to address from the people's side?
No, Judge.
So I'll adjourn this to December 4th at 8:15 a.m.
December, and I'll do the stip in order with Ms. McClure's permission.
No objection.
All right, so Mr. Ryan, your next date is December 4th at 8:15 a.m. You'll log in with all the same Zoom information that you used today.
Okay, thank you.
Thank you.
I believe that concludes my docket with you this morning, Your Honor.
You also had Larry Clark.
Larry Clark. Okay. I'm sorry.
Oh, you know what? That was a summons for probation violation. And is Larry Clark present in the courtroom? Okay, and he's not here. So you're all set then, Rhonda.
Thank you.
Okay, so let's see. Mr. Clayton, are you ready to proceed with Mr. Jacobs?
Yes, Your Honor, I do see him present in jail room 8.
Okay. This is file 24-21919-FH, People versus Andrew Frederick Jacobs. We are here today for a pretrial conference in this case. And we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people.
Good morning, Your Honor. Spencer Clayton appearing on behalf of Mr. Jacobs, P number 77302.
All right, and Mr. Jacobs is also present by Zoom from the jail. Where do we stand with this case today?
Your Honor, the people did reach out with an offer yesterday afternoon. I will need to meet with Mr. Jacobs and discuss that offer. We have made substantial progress, and I think we're getting close to a resolution, Judge. So I'd ask for another pretrial date.
So I'm sorry, Mr. McCready, anything we need to address from the people's side?
Well, just that this is not our initial offer. This revised offer has come after some discussions. So, but yes, it is correct. And we have no objection to adjourning this so that they can decide whether they want to take it.
If we adjourn to November 13th, is that a sufficient amount of time, Mr. Clayton?
It is, Judge. I'm just looking at my schedule. That works.
It's fine with people.
Okay, so November 13th at 8:15 a.m. All right, anything else we need to address with the case today?
No, Your Honor.
No, Your Honor. Mr. Jacobs, I'll see you today.
I have a question. I'd still like to know if I can be released on bond. Right now, I've lost my home is being taken from me. I'd like the chance to get out and put some of my stuff together. At least to get my affairs in order, Your Honor.
The court's previously heard a motion and made a ruling on the bond situation. Mr. Clayton, would you be willing to do a stipulation in order for the adjournment?
Yes, Your Honor.
You can sign my name.
Thank you.
All right, Mr. Jacobs, you can let the officer with you know that you are done with court for today.
Okay.
Okay, this is file 24-21804-FH People versus Larry Dean Clark. This was set for a hearing on a summons for probation violation this morning. Record to reflect was set for 8:15 this morning. Mr. Clark was ordered to appear. It is now 9:04 a.m. and Mr. Clark has failed to appear. He is not present in the courtroom, nor is he logged into the Zoom session. I am going to issue a bench warrant for his arrest, and I will set bond on the bench warrant in the
Hey, Your Honor, what date did you, or what amount did you set on that bench warrant? You kind of cut out.
Sorry, $25,000.
Perfect, thank you.
Ms. Dumont, are you ready to proceed with Mr. Torres?
Yes, Your Honor.
Okay, this is file 23-21668-FH. That is set for a final pretrial. It is also file 22-20819-FH and 22-20820-FH. Those are set for hearings on probation violations. We're proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
BB McClure, may have the people.
Katarina Dumont for James Daly for Mr. Torres.
All right, and so this is a final pretrial. Are we ready to proceed to trial in that 23 case then?
Your Honor, in the 23 case, Mr. Daly, I believe, spoke with Mr. Torres yesterday at the jail, advised him of the offer, which would be pleading to the attempt for substance possession. Habitual is dismissed, and I believe he would like to take that offer.
Okay, your audio dropped out a little bit. Did you say there's an attempted that's offered?
Correct. Count one would be attempted, and then the habitual offender fourth offense would be dismissed.
Okay. I would need an amended information unless one had already been filed.
Judge, I apologize. We didn't have the underlying pretrial on the docket today, so we didn't prepare anything for that plea. All I see is a probation violation on the docket, and I'm not even sure who the actual prosecutor on this is.
I believe the prosecutor is Mr. Sneed, and we reached out yesterday and advised him that we would like the offer and to prepare the amended information.
Yeah.
Would the court be willing to give us a week to get this stuff prepared? Like I said, we just didn't have it on the docket today. All I saw was the probation violation.
Could we do that on November 7th is the trial date? Could we just do that morning?
That should be no problem on our end.
Yeah, that would work.
Okay. I just got a pretty booked up Wednesday morning next week already, so it would be easier if we waited till the next day.
We can even do it tomorrow, later in the morning after your sentencings, if that works.
Give me 1 second, let me look.
You could do
That
that
would
at
be fine.
11.
Yeah, we
11
could do that.
Tomorrow at 11?
We could actually do it at 8:15. I only have one sentencing tomorrow.
Your Honor, Mr. Daly has a in-person, well, we both have in-person sentencings in Jackson, tomorrow morning.
Okay,
So, but 11 should work.
but you could do 11. Okay, so let's set it for 11 o'clock tomorrow morning then.
Okay.
Okay, thank you.
Okay, thank you. Mr. Torres, you can let the officer with you know that you're done with court for today.
Thank you.
Could we have Tyler Hospital for him, please? Thank you.
All right, Mr. Goebel and those here for that case, I apologize. I didn't realize when I called for Mr. Goebel that I didn't have his attorney logged in yet. So as soon as Mr. Goebel's attorney gets logged in, we will proceed with that case. Mr. Murphy, have you had any contact with Mr. Wagner?
I have not. Let me try to reach out to him. So I apologize, Your Honor.
Not a Mr. Wagner here in the courtroom. Oh, you're here. Okay. So Mr. Wagner, you can come forward and sit here closest at the table closest to the television. Mr. Murphy, Mr. Wagner is here. Do you need to speak to him?
If I could briefly, Your Honor, if he has a phone, I could call him, or he could use the Zoom.
Mr. Wagner, if you want to step out to the hallway, we'll set up an iPad and you'll be able to speak to Mr. Murphy privately. Okay.
Thank you.
What's that? I was trying to wait on her because we need to clear the courtroom. All right, Mr. Wagner, are you there?
Yes, sir.
Okay, and Mr. Dagen-Rogosian, are you there? Okay, one second.
Judge, this is Mr. Murphy's.
Oh, I'm sorry. I got turned around. I apologize. So, Mr. Murphy, I'll put you in a breakout session, right?
Thank you, Your Honor.
Okay, and then the gentleman at the jail, you are Mr. Hostler, correct?
Yes, Your Honor.
Okay, Mr. Dagen-Rogosian, do you need to speak to Mr. Hostler?
I don't, but similar to another case, this is going to be a HIDA case, just for the court's consideration.
Okay. All right, we may as well do those now. So I apologize, ladies and gentlemen, they're here in the courtroom. We're going to do a case that involves closing the courtroom under the Homes Youthful Trainee Act. So I'm going to need to have you step outside to the hallway. As soon as we're done, I'll bring you back in.